Good afternoon, everyone. I think we'll make a bit of a start. I'm going to keep these opening remarks quite brief, but it really is just to extend our warm welcome to the Moot Courtroom here at Ulster University. In terms of just a couple of housekeeping announcements, there should be no fire alarms that are due to go, and many of you have been here earlier, so you know the way out is just through these doors here, and there's toilets just at the lifts. But it really is just to say welcome everyone to the event here today, and we're really looking forward to having the fantastic presentation on this research by the wonderful panel. And I will just leave it there. So welcome everyone, and thank you.
Hi everyone. For those of you who are here this morning, we're calling you the Double Dippers. I'm sorry you've got a second dose of me, but it's going to be relatively brief, and we've got a tremendous panel of people later who you'll be hearing from. Sarah, thank you very much for hosting us. It's fantastic, this place, and the Moot Court is fantastic. I don't know whether Hugh gives you memories of bar school, but it gave me quite a fright when I walked in, and it really will set barristers up, the future ones coming through, so it's a great idea. So this is our latest research in our series of reports looking at the implications of the Windsor Framework. 4 years into our role, monitoring the no diminution commitment, we've seen some very significant steps forward in terms of clarity with the High Court judgments in the Dillon case and our own motion case on the Illegal Migration Act, both of which largely agreed with our analysis, so that was very pleasing and very satisfying. The judgments didn't come out of the blue, and they weren't unexpected, at least for us. The arguments put to the court were the result of several years of painstaking analysis and some very good lawyers we engaged putting the arguments for us. Working alongside our colleagues at the Equality Commission, we developed and ran an extensive research programme, as in the case of today's report, by eminent scholars. I hope you don't think I'm going to embarrass you, across the academy, within and beyond the island. So thank you very much for your contribution. It really has helped us discharge our functions. We commissioned a series of legal opinions, as well as conducting a lot of in-house work. And I thank my colleagues who are here, because I know we were asking a lot of you to get on top of what was very difficult and very labour-intensive work. And a lot of sort of head-scratching went on, so we're grateful to you for that. We do now have, I think, certainly a better body of law and analysis to draw on. At the start, we were trying to work out what this thing meant. Was it broad? Was it narrow? What exactly was it going to do for us? And was it going to fill these gaps that we feared were going to be left after Brexit? And I think what we're discovering is that, yes, it is broad, it fulfills its purpose, and it really has teeth. What we have as well, though, earlier on I talked about some of the litigation. I don't think I'm going to repeat it here, but what I would like to say is that on top of litigation, that's only one aspect of what we do, and it should always be a last resort. But these pieces of work have breathing space that you don't have in a court setting. So you have time, space, and the ability to really explore and test each other and talk about these issues. And my colleagues in the dedicated mechanism are constantly discussing at a level which sometimes I find hard to follow, but they really have honed this to a remarkable level. We have this theoretical framework now upon which we can now build litigation as and when needed. This piece of research emerged out of the questions and apparent contradictions regarding the status of the EU Charter and EU general principles in UK law. And there was quite a debate at the start about whether it applied at all, and if so, in what way. So whereas the EU Withdrawal Act provided that the Charter was not part of UK law and restricted the reliance on EU general principles, the Commission took the view that there was greater complexity to the situation given Windsor Framework Article 2. Cutting across the no diminution commitment in Windsor Framework Article 2 is the rest of the treaty, And crucially, this includes Articles 2 and 4 of the Withdrawal Agreement, in which signatories agreed the status, interpretation and enforceability of its terms. And all I would add there is all of this was done knowingly, democratically, and agreement was reached. Making these commitments domestically enforceable is the, in quotes, conduit pipe of Section 7A of the EUWA. Underpinning Windsor Framework Article 2 and the rights in the Belfast Good Friday Agreement, we identified some 70 measures of relevant EU law, which must be interpreted in line with treaty commitments and domestic law. So our questions for our very eminent academic researchers, for Tobias, Eleni and Anurag, who are here in the front row, were essentially threefold. How and to what extent did the Charter and EU general principles continue to protect rights in Northern Ireland? How far can domestic incorporation of the treaty take us in terms of enforceability and the apparent contradiction on the face of the EUWA? What does Court of Justice your case law tell us about this? Now, there's a lot of it, and there's a lot of EU law, so that took some time. Our timing was fortunate. The EU Charter has been central to the recent cases in Article 2, and I'm pleased to say judgments to date have been consistent with our analysis. And I said slightly grandly earlier, we're very pleased that we've been essentially vindicated, or at least somebody else has agreed with this. I would like to welcome and introduce properly the authors of this research, just so you know what we're dealing with here. We're dealing with proper analysis. Tobias Lock, Professor of Law at Maynooth University, School of Law and Criminology, Founding Director of the Maynooth Centre for European Law. Welcome. He's on the board of the Irish Centre for European Law and currently serves as an EU law advisor to the Scottish Parliament's Constitution, Europe, External Affairs and Culture Committee. So very well placed indeed to assist us with this. His current research focuses on EU fundamental rights law, EU accession to ECHR, fallout from Brexit, particularly its effects on the devolved parts of the UK. So we're not going to let him leave the room, I think. Dr. Eleni Frantziou, I hope I pronounced that correctly, Associate Professor of Public Law and Human Rights at Durham Law School, University of Durham. He's written extensively about the application of human rights in the European legal space and the human rights implications of Brexit, with a particular focus on the EU Charter of Fundamental Rights. Her research has been cited by national and supranational bodies, including parliamentary committees, the European Court of Justice, EU Fundamental Rights Agency. Again, you're staying with us for some period of time. And lastly, but by no means least, Anurag Deb, PhD graduate, one of our own from up the road, Queen's Law, paralegal at KRW, which is Kevin Winter's law, LLP, undertaking his thesis in legislative drafting and has written extensively on issues around the Windsor Framework. And I know you've been actively engaged in this since the very first. So welcome all of you. You really are, you've provided such a great contribution for us so far, and we're looking forward to hearing what you have to say. And we hope you're going to continue to work with us, by the way. Thank you. I think you're going to do we're going to call them up. Am I right about that? Yeah. Professor Tobias Lock, you first, if I may.
I'll start. Thank you very much. Thank you very much, Alison, and for the kind introduction and for having us here today. It's been a bit of a delay. We were meant to launch this in May, and then there was a general election called, and everybody thought, well, we better delay this, even though I don't think we're going to be too controversial anyway. Thanks also to Eleni and Anurag. It was a fantastic experience working with you over the last 1.5 years or so that we've been doing this. And you know, I've learned a lot. It was great research, and I think the report is very good still, having read it again yesterday. So. And so should you, actually. And thanks a lot, obviously, to the team at the NIHRC. Ailish, Claire, and Emma, I think, was involved at the beginning as well. She has moved on to, more exciting stuff, I guess. And obviously to Professor Colin Murray, who did the peer review in about 24 hours or something, which was remarkable. And thanks a lot to you, too, for all your support with this. Now, I've got the flicker here. So what we want to do is we want to briefly talk you through the report. We're just going to highlight some of the highlights, the things that we find interesting. Obviously, there's a lot more in there. It's 92 pages long altogether. So we can only do so much in 40 minutes. So this is the structure of the report. Basically goes from the broad to the specific. We first of all discuss the Charter of Fundamental Rights. What is it? When does it apply? Which is obviously the big question when it comes to the Charter. How is it transposed, or does it still exist in the UK in general? Answer no. Does it still exist in Northern Ireland? Well, probably yes, at least under certain circumstances. And that's when we start with the Windsor Framework analysis. And there are really two avenues through which the Charter can apply. It's either through Article 4 of the Withdrawal Agreement itself. I'll explain that in a second. And obviously through the magical and famous Article 2. Then an important question is obviously, why does it matter? Why does the Charter matter at all? We have the Human Rights Act, we have the ECHR, but what does the Charter add? And that's obviously a key question from a practical point of view, because, we academics, we don't care about these things, but everybody else does. So why does the Charter matter? And it's mostly because it brings with it remedies that you wouldn't have available at your disposal ordinarily. Notably, of course, the EU law remedies of primacy. That means you get a disapplication of acts of the UK Parliament, which you wouldn't have under the Human Rights Act. The best you can get out of that is your declaration of incompatibility, but you still lose your case, right? Here you can win your case because the act will be disapplied. And obviously, the other and slightly less obvious, or maybe slightly less explored remedy is Article 47 of the Charter, which is the equivalent to Article 6 of the ECHR, which can, we don't know yet, but I think it can potentially be used to create new remedies that simply are not available at the moment in the law of this jurisdiction. And that's obviously an important factor as well. And then we'll look at some recent case law and future questions, because there's a lot of things that are still unknown about the Windsor Framework, notably the Stormont break, if it was ever used, and what that would actually mean for all of what we said before. But Anurag is going to deal with that. I barely understand that. So there we go. Now, what's the basics? The basics of the Charter. The Charter has been in force for 15 years now, since 1st of December 2009. Previously, the EU legal order protected fundamental rights as well. They were called General Principles of EU Law. They were unwritten, which is always a bit unfortunate because you can't look them up. But in essence, they were the same rights that the ECHR protects, and maybe a few more. But it was never quite so clear. So fundamental rights are nothing new, but that they are written down in this catalogue of rights is relatively new. And this is why this area of law, even at EU law level, is still moving quite well. It goes through stages, but it's moving quite rapidly, in particular when it comes to remedies. Now, what we have done in this report is we've mostly focused on the Charter. It's the interesting bit. But you can read this as the general principles as well. The general principles really mirror the Charter, or the Charter mirrors the general principles. It codifies them. That was the whole purpose of the exercise at the time when it was adopted. Now, when does the Charter apply? The first important issue, now obviously anybody who's familiar with the Charter will know this, but the Charter has a limited application when it comes to the member states. The Charter is first and foremost there to tie the EU down to a basic standard of human rights protection, right? So EU measures have to comply with the Charter. But also member state measures have to comply with the Charter, because member states are the ones who apply EU law on a day-to-day basis. The EU itself, EU institutions don't really do that very much, apart from competition law. Yesterday, Ireland, I live in the south, 14 billion richer, all of a sudden. That was one example where the EU actually does things in practical terms, in administrative terms, but most of the time it's the member states that are implementing union law. And when they do so, they act as agents of the EU, and therefore they have to comply with Charter provisions. And that means, from the perspective of Northern Ireland, of course, whenever a Northern Ireland or UK executive agency, department, whatever, public body, is implementing EU law, they are bound by the Charter. Now, obviously, since Brexit, there's been a break, but because of the Windsor Framework, we can re-establish that link, at least in certain cases. Okay, so that's the important hurdle. So the Charter doesn't always apply. So for every case you're looking at, you always have to ask yourself, does the Charter actually apply now in this case? Yeah, and that can be tricky. The test is basically whenever the state body, public body, applies EU law in some shape or form, either it deviates from EU law rules or it applies them one-to-one, say a European arrest warrant or similar, they are bound by the Charter. They're implementing EU law. So it's relatively straightforward, actually. So the Charter always applies to the EU, only applies to member states when they're implementing EU law. Examples, a member state freezes a person's assets based on EU sanctions. They're not happy. They go to the national court. They can invoke the Charter, amongst other things. A member state expels an EU citizen from its territory. You might have that here as well. Obviously, nothing to do with the Windsor Framework because it's in the withdrawal agreement itself, but still, EU citizen who has settled status is expelled because they've committed a serious crime. They can invoke the Charter, right to family life, or something similar. You've got a revocation of planning permission because there was no environmental impact assessment carried out. Well, okay. Implementing EU law, Charter applies. Well, it mightn't help you, but it's still. Member state executes a European arrest warrant. You're arrested by the police. Does the Charter apply or not? Well, I can't tell you because I don't know why they arrested you. Have they arrested you because you were rioting in a pub? Charter probably doesn't apply. Have they arrested you because there's a European arrest warrant out for you or an arrest warrant under the withdrawal agreement? Or maybe the Charter applies, right? So that's where it gets a bit trickier. But the Charter does not apply when there's no connection to EU law at all, in purely domestic circumstances. But it's really important to look at it in detail. What is the public authority actually doing? What is it applying? What laws are they relying on in actual fact? Now, what about UK law? We have to probably go there very briefly because it's important now, because the UK government probably still, I don't know, they haven't probably revised that part of since taking over. They claim the Charter does not apply in Northern Ireland. That was their statement, right? Because, they said in Article 5.4 of the EU Withdrawal Act 2018, the Charter of Fundamental Rights is not part of domestic law on or after 1st of January 2021. That was somewhat modified in the beginning because they said, well, but the general principles still are under certain circumstances, which, as I said before, mirror the Charter. But since the Rule Act 2023, which entered into force while we were writing this report, which was really annoying, since that particular piece of legislation, even the general principles have been expunged from general UK law. So normally, that would be quite a depressing thing to have to conclude with if I was going to give you a presentation on the Charter at this stage. But we have Section 7A of the UWA, which is really the key provision, which says that the EU withdrawal agreement is part of domestic law. It also says that the rights and so on, which are created from time to time under the withdrawal agreement, should be given effect without further enactment. That is exactly the same wording that you would have had in the European Communities Act 1972, so it's just a copy and paste job. And it says that any enactment, including the UWA itself, so it means Section 5, which has taken the Charter out of it, and the new amended Section 5 since 1st of January is subject to Section 7A. So that means it doesn't apply, really. Section 7A applies. Those exceptions don't apply. So that means while all EU fundamental rights have been removed from UK law in general, broadly speaking, they can and do apply in Northern Ireland still because of the withdrawal agreement, because the withdrawal agreement has been given effect and is still being given effect under Section 7A. So that's important. Now, you knew that anyway, but I'll tell you just to be sure. As I said before, there are two avenues, we think, under which the Charter applies. the one that everybody's talking about, Article 2 of the Windsor Framework, the no diminution guarantee. Yeah, Eleni will talk about that in detail in a few minutes. And also Article 4.3 of the withdrawal agreement. Now, Article 4.3 might be less well known, but it's important all the same because it says something very simple, that the provisions of this agreement, of the withdrawal agreement, referring to union law, which a lot of them do, shall be interpreted and applied in accordance with the methods and general principles of EU law. So that means that anything in the withdrawal agreement, including the Windsor Framework, that refers to EU law, which is basically much of the Windsor Framework, really, yeah, all the annexes 2, and so on, they must be interpreted and applied in accordance with the methods and general principles of EU law. And of course, if you're applying, the whole purpose being that obviously EU law should be applying in the same way as it applies in the EU, that means you also have to interpret those rules in line with the Charter and apply them in line with the Charter, okay? That means for the Windsor Framework, which extends much of the single market in goods to Northern Ireland, that for all these specific provisions, in respect of all these specific provisions, the Charter still applies. Now, you might say, well, okay, if you look at the rules on customs or something, how is that relevant? I'll give you an example in a minute, maybe a somewhat extreme example, but to show that the Charter does actually matter, even when it comes to that. And then we've got the Windsor Framework, Annex 1, obviously being a special case, and then the RSEO section of the Belfast Good Friday Agreement. We'll come to that in more detail. When it comes to Article 4, what examples could we make referring to EU law or concepts or provisions thereof? One example is that the free movement of goods, Article 34 of the Treaty on the Functioning of the European Union, which allows for free movement of goods, is applicable between Ireland and Northern Ireland. So I bought a lot of wine there earlier this morning because it's much cheaper here. I'll bring that back later across the border, and I'm enjoying free movement of goods while I'm doing that. And the reason this article is obviously the Windsor Framework. So how could that be a human rights case? Well, that can't be a human rights. Well, it might be, but it's not really a human rights case. But what happens if you have, say, a protest that is going on? Things have calmed down maybe a little bit, but imagine a protest against the Irish Sea border. And the protesters are saying, well, we're going to block the motorway, right, between Dublin and Belfast for 24 hours, and we're going to have placards and say, no Irish Sea border, to make it clear, and show them what we think. And, that could happen, right? It's a conceivable thing to do. And imagine now the authorities say, well, we can't do that, and they remove the protesters by force. The protester is not happy. They go to court, and they say, well, our right to freedom of assembly has been violated. And not only do they invoke the ECHR, they also invoke the Charter, Article 12, I think. 12. And does the Charter apply? And the answer is yes, the Charter applies because of Article 4.3 of the Withdrawal Agreement, because the provisions in the agreement, Windsor Framework, Article 30, makes Article 34 of the TFEU applicable. Free movement of goods has been restricted because of the protest. Can I restrict it because of the protest? Well, if the protest is a lawful assembly, maybe you can. There's case law by the Court of Justice of the EU on exactly that kind of topic. So the Charter applies. That might be one example. Another example where this is important is certainly the remedies again, and in particular Article 47 of the Charter, the right to an effective remedy applies to each and every provision that is made applicable by the Windsor Framework. So you have the Charter applying there through this particular avenue. And that's an easy avenue. You don't have to show no diminution, none of that stuff. All of the 6 stages test, maybe it'll be 7 stages next week, or who knows. You don't have to show that. You don't have to show the no diminution. It simply applies. And that's actually quite neat, and it's important to know. Now I'm going to hand over, I've exhausted my 13 minutes of speaking time, to Eleni, who's going to talk you through Article 2, and then Anurag is going to do the rest. Thank you very much. Now, on you go.
Thank you very much. Sorry, that difference in height. Right, thank you very much. Thanks very much to my co-authors, first of all, as well, on my part too. It's been wonderful working with. Bizarrely, this has been a really challenging piece of work, but it has been wonderful actually working on this, and it didn't feel very tiring. So thank you very much. It has been a wonderful collaboration, and thank you also to the NIHRC for giving us the opportunity to do this work. It has been wonderful working with you also, and. I won't bore you too much, but also thank you obviously to Ulster University for hosting us today. It is a very, very nice room. Right, so carrying on then from Tobias, who has very kindly explained some of the difficult debates on the application of the Charter in relation to Article 4 of the Withdrawal Agreement. My job is to talk you through Article 2 more specifically, as well as the juicy stuff on why should you care about the Charter. Why does it actually matter? What does it do for you, as individuals, but also for courts in this jurisdiction? So, what's the nature of the applicability of the Charter in Northern Ireland through Article 2 is, of course, written to ensure that there will be no diminution of rights, safeguards, or equality of opportunity as set out in the rights, safeguards, and equality of opportunity section of the Good Friday Agreement. Now, you all know what the rights that the Good Friday Agreement protects are, but in broad terms, those can be considered to correspond to a series of obligations under the Charter. Now, I made the mistake of writing them down without actually writing out what they are, so you'll test my EU law knowledge here because they don't actually correspond to the Convention. So they can broadly be considered to be Articles 1 of the Charter, human dignity, Article 10 of the Charter, freedom of religion, Article 11 of the Charter, the freedom of expression, but also we could add here, as Tobias mentioned, the freedom of association, Article 12, Article 20, equal treatment, Article 21, non-discrimination, separately protected, Article 22, cultural and linguistic diversity, Article 23, equality between men and women, Article 26, protection of persons with disabilities, Article 40, voting rights for municipal elections, and Article 45, free movement. But we could, of course, add a series of other rights protected in the Charter, for instance, as mentioned earlier, Article 47, the right to an effective remedy, as well as a series of other defensive rights and employment protections, such as social security and so on. So in relation to those rights, which I in an orthodox way sort of discussed before the previous part of my slide, there is a twofold commitment. Now, with regard to the first, to the measures listed, specifically referred to, in Article 2, the equality directives, the core equality directives protected therein, we know that these measures have to be interpreted and applied in accordance with the Charter, and that there also has to be dynamic alignment with any interpretations of the Charter or of those measures made subsequently by the European Court of Justice. So we have this commitment that is sort of not frozen in time, but goes beyond what currently is in the listed documents. Okay, so you've got to look at the documents themselves, but also at what the European Union is doing, and particularly what the European Court of Justice is saying about those instruments. So if, for example, an equality directive is interpreted more expansively in the context of non-discrimination for persons with disabilities, then that application has to also be applicable in Northern Ireland. Now, there is a second and more fluid aspect to the Article 2 commitment, which I will spend a little bit more time on, which is the frozen in time, if you like, non-diminution commitment, which concerns the rights, safeguards, and equality of opportunity, part of the 1998 agreement, more broadly than the measures that are specifically listed. Now, we know that because the protocol the Windsor Framework says, including the annexed measures, right? We know that Article 2 doesn't just mean those measures, okay? It can mean any measure relating to the RSEO section. And we know from case law that, and particularly from the Spack and Dillon decisions, that the test for checking whether the RSEO section is engaged is the following. It's a 6-step test. A right or equality of opportunity protection must have been included in the relevant part of the Belfast Good Friday Agreement and must be engaged. That right must have been given effect in whole or in part in Northern Ireland on or before the 31st of December 2020. So that's why the non-diminution commitment there is in a way frozen in time. The Northern Ireland law must have been underpinned by EU law. And that's where really that core element of our report comes in. That third part of the test includes the question of the scope of the charter. So in that part of the test, you need to think about, well, would the charter have applied? Was this something that fell within the scope of the implementation of EU law in the context of the charter as detailed in the Frantziou decision, which we explain in quite a bit of detail in the report. So has that underpinning been removed in whole or in part following withdrawal? And has that resulted in a diminution of protection? And would that diminution basically not have occurred if the UK had remained in the EU? Right. So assuming that these criteria, these 6 steps have been met, you can rely on the Charter of Fundamental Rights to ground a claim that could include, as Tobias mentioned earlier, disapplication, wide-ranging interpretation of the relevant provisions, etc. Now, some examples of what this could mean. So I'll start from some of the easy examples and move to the less easy ones. Let's see how far we can go. And in the report, we do explore various examples that we think are likely and others that perhaps you might consider less likely. It remains to be seen in litigation how far that RSEO section will expand. So something that is clearly captured, we think, in the RSEO section is mentioned in the UK government explainer on the Windsor Framework is the Parental Leave Directive. So the interpretation of a measure like that has to take into account Article 33 of the Charter, the right to parental leave, as interpreted in the case law of the Court of Justice, for example, in Caisse pour l'avenir des enfants, which is a case that concerns a restrictive interpretation of parental leave in Luxembourg, where Luxembourg basically was trying to give parental leave only where an individual was employed at the time when the children were born. The court actually said, well, no, you can't do that. Even if they started working for you later and they claim parental leave, you can't actually diminish that right entirely. That would undo the protection, the fundamental protection of that right in the Charter. So the Parental Leave Directive has to be interpreted, as encompassing Article 33, Paragraph 2 of the Charter. Another example, generally rights contained in the ECHR and ratified by the UK. So a good example here could be Article 8 of the Charter of Fundamental Rights, which expands Article 7 of the ECHR, the protection of private life. The Charter right is more specific here. It is the protection of private data specifically. Obviously, the GDPR did apply in the UK, and there is the UK version of the GDPR. The application of personal data could be considered to fall within various aspects of both EU law applied as EU law under the withdrawal agreement, as well as aspects of the Windsor Framework, including various aspects of equality of opportunity, for example, in areas of artificial intelligence and so on. So there's quite a lot of scope here to apply Article 8, to apply interpretations that take into account Article 8 of the Charter that could be more expansive than those given under Article 8 of the Convention. Another example is, and this is where it gets more tricky, a question really, how broad that RCO section will be considered to be. So could it be considered, for instance, to encompass protections like the nebis in idem principle, which is a right that is protected in UK law in some forms, for example, in the common law. It's also part of the Schengen Agreement. It's also protected in the ICCPR. So it's clear that the UK is bound by it, but the UK hasn't signed up to the protocol protecting this right in the European Convention. So there, it's unclear whether there is an ECHR dimension to the provision that would strengthen its presence perhaps within the RSCEO section. But it is a fast-developing area of the Charter. It clearly is protected in the Charter of Fundamental Rights. And you could say that things like extradition could come within the RSCEO section of the Good Friday Agreement in several ways. For example, a recent case law concerns extradition of a Serbian national to, I think it was the United States, actually, from Germany. Yeah, I'm right. Yeah. Even though they had fulfilled their sentence, something like that could come up. It's unclear whether that would have been captured by the ECHR, but it would have been captured by the Charter. Would there be an RSCEO relevance to this? Again, if there was an aspect of, say, equality within the community that could ground that claim, then perhaps the Charter would again apply. So there are ways of being more creative about the sorts of provisions that would come within the scope of the Windsor Framework under Article 2. And there are, of course, also more restrictive ways of seeing what comes within its scope also. Again, that's very much still open for discussion. Now, oh, I'm sorry, I just realized this clicker thing. It is my fault, actually. Everyone has been doing it. It didn't quite work. I was referring to this judgment just on the slide there. I just realized you weren't seeing it because it's too far away from me. Right, there we are. Okay, let's not do that in lectures. Now, the bit that you've all been waiting for, effects of applying the Charter. So why does it matter that the Charter applies in Northern Ireland? Basically, the first thing that I think the report clarifies, and hopefully this is quite novel, is that the Charter isn't just important because it gives rise to direct effect, and we'll talk about that in a minute. It's really important. It does wonderful things in that context too. But it is important to understand that it is a document with a binding character more generally. Whenever a situation falls within the scope of EU law. And so it's binding for UK public authorities whenever the conditions of the Windsor Framework or the SPAC test are met. But assuming you are within the scope of EU law, so assuming that there isn't a domestic implementation of the Charter, it's also binding for private actors. So, for instance, employers are bound to ensure the protection of fundamental rights under the Charter, and it's quite unusual in those ways. It's quite unlike other instruments of rights protection, like the Convention, which are purely focused on state action. Under European Union law, rights are applicable in both vertical relations with the state as well as in horizontal relations between private parties. So, for equality commissions, for example, or even employer associations, it can be quite important to know what they need to do under the Charter still, because that obligation could come before the courts. And we have seen, obviously, several horizontal cases at the Court of Justice. I mentioned here just some of the classic ones, Defren and Kuchuk-Devici, which are non-discrimination cases. Now, effect 2, remedies. Content. I don't know what I'm doing here. Important in terms of content and scope of the protected rights, it is as well. As I mentioned earlier, there is a parity between some protections of the Charter and the Convention, but not always. And in addition to things like nebis in idem, we can think about Article 21 of the Charter and obviously all the Annex 1 directives. The Convention doesn't protect equality in a self-standing way, so clearly, it does, but the UK hasn't signed that bit. So anyway, it hasn't signed Protocol 12. Article 14 of the Convention only protects non-discrimination in the context of the exercise of other Convention rights, whereas the Charter protects them in a self-standing capacity, and as I mentioned in the beginning, has actually a host of provisions on various aspects of equality and inclusion. So there is a clear benefit to using the Charter there from a content perspective. Then there's dignity. Whereas, of course, the Convention protects the right to human dignity in some form in Article 3, freedom from torture and inhuman or degrading treatment or punishment. There is a self-standing right to dignity under the Charter, which has recently been explored in litigation, particularly regarding minimum subsistence benefits, such as in the CG case. So this is very interesting and useful to think about. Private data, an area that I mentioned earlier. Article 8 of the Charter goes beyond the Convention substantively in protecting private data. The Court of Human Rights has never actually acknowledged or accepted the existence of a self-standing right to be forgotten, for example, right to erasure of private data, which the European Court of Justice has. So this is quite an important difference. And again, employment rights. Employment rights, the entire Title IV of the Charter, which the UK government had originally suggested wasn't in fact justiciable. We now know that it is. And this includes important recent case law, such as Bauer and X, or KL actually, X versus KL, which concern the right to paid annual leave, as well as the right to fair working conditions and protection from unfair dismissal. So all of those protections are not found in the CHR, so they're a clear benefit of the Charter. And of course, the right to an effective remedy, which was mentioned earlier already on several occasions. Article 47, which has been affirmed in recent case law of the Court of Justice as perhaps the key provision that is the vehicle to the effective protection of all other rights, including non-discrimination, but including also other areas such as employment disputes. And has been recognized as relevant to the protocol in the NIHRC judgment. Now, the final bit that I will talk about, and I did promise this, so I've made quite a hype here, remedies. Now, why should you care about the Charter, or why should your courts care about the Charter? The one thing that hasn't been explored in litigation yet, or hasn't been explored to the extent that perhaps we thought and suggested in the report it should be, is that they need to strive for a Charter-compatible reading. And that reading can be, of course, we know that the domestic courts do that, also in the context of the Human Rights Act, so that's not unknown to them. But what is, we argue, slightly unknown, is the limits of that duty. The Human Rights Act is very clear that the compatible reading is as far as it is possible to read a particular provision compatibly with human rights. The domestic courts will do so. But the EU reading can be a lot more wide-ranging than that. And in Pfeiffer, the European Court of Justice basically said that domestic courts have to do everything in their power to find a compatible interpretation in any aspect of domestic law. So they have to survey the entire body of domestic law to find a compatible reading. So that goes arguably beyond what we're used to saying under Section 3 of the Human Rights Act. Now, where a Charter-compatible reading is impossible, and where a right has already been breached, obviously, we have, in most cases, not in respect of all Charter provisions, but for those that are clear, precise, and unconditional, we can have direct effect. So an individual can invoke those rights before a domestic court and have a particular provision of primary legislation disapplied in order to find a remedy. Now, we know that the domestic courts will do so. There have been cases about this, of course, also pre-Brexit. The Benker decision of the Supreme Court is the key one. But the obvious consequence of applying the Charter in Northern Ireland is that this can still happen here as well. Or that this can still happen here, rather, while it has been removed from all other parts of the United Kingdom as a possibility. And the other possibility that has, of course, been removed elsewhere and that could still be relevant here. And I'm seeing Colin smiling over there, is state liability and damages, a litigator's favorite, really. Although it's a funny one, because in the fundamental rights context, it isn't being used very much, at least at the European Court of Justice level. So this is an interesting one. There's a lot of political hype about state liability, but actually very few cases about it. Because what the European Court will do instead is often rely on Article 47 in conjunction with other provisions. Thank you very much. I will hand over to Anurag for the crystallization of the Charter in Northern Ireland.
Hi, everyone. I'd just like to echo both Tobias and Eleni. It was a pleasure working with both of you throughout the entire thing. The only hiccup was when the Retained EU Law Act was enacted, although I don't think I can blame anyone here for that. And we're not really going to go into the Rail Act. In this presentation, we don't really go into it in much detail in the report because it's insane. But anyway, and it's also largely irrelevant to what we talk about in terms of charter applicability. But so what I'm going to do is talk about the way in which recent judgments have crystallized the position of the charter in law within this jurisdiction, and look towards some future questions which might be litigated in light of the ever-evolving state of the Windsor Framework. Especially the storm and break. So the crystallization of the Charter really started in 2022 with Spuck in the High Court. This was Mr. Justice Colton, and this was unsuccessful as a challenge. It was a challenge regarding the rights of people with disabilities under the Charter, and how that interacted with the, at the time, very new provision for abortion services in NI law. It failed, but it set out an important test that was then subsequently affirmed by the Court of Appeal in the same case, which is what we have as the six-stage Spuck test that Eleni talked about earlier. And of course, we have cases like Angesum, which concerned an Eritrean national who was an asylum seeker who was moved against his will to Scotland. That too failed, but again, it set an important benchmark that the Charter applies here, regardless of what Section 5.4 of the EUWA says. And I'll get into that in more detail later. And of course, this year we had Dillon and the NIHRC, GR295 cases, two back-to-back disapplications within 6 months of each other. Never happened during EU membership, and now is happening after Brexit. So it's been a fun year. Anyway, so what these cases demonstrate is that there is a through line, a very clear line, from Article 2 and 4 of the Withdrawal Agreement. So Article 2, definitions of union law, includes the Charter. Article 4, methods of application and interpretation of EU law, particularly Article 4, 1, and 3 we saw earlier in terms of methods of interpretation and so on, all the way through to Windsor Framework Articles 2 and 13. 13.2 of the Windsor Framework in particular is about the duty of domestic courts to follow Court of Justice case law when interpreting or enforcing or scrutinizing union law provisions. Via Section 7A of the EUWA, which, as Tobias said at the very beginning, is almost a carbon copy of Section 2.1 of the ECA. It has also been similarly described as a conduit by the Supreme Court in Alistair. And the Supreme Court described Section 2.1 as a conduit in Miller 1. So that should give you a fair idea of, this isn't, I like to think of this as, it's not new, it's the same in a different sort of packaging, effectively. We spent roughly 40-odd years watching the evolution of EU law, but so this isn't really new just because we've left, because it still continues to apply. So the Charter has direct effect in Northern Ireland, and it does so insofar as the conditions of direct effect are met under EU law, as Eleni explained, clarity, precision, and conditionality. If a charter provision has those, or satisfies those three key conditions, it has direct effect, as does every aspect of union law and provision of the withdrawal agreement and provision of the Windsor Framework. If it satisfies direct effect, it has direct effect here. And the reason I keep stressing this is I will get to a favourite argument of the UK government in these cases, which is interesting. Despite the fact that Section 5.4 says that the Charter is not part of domestic law after Brexit. So this has subsequently been held to be the case in the NIHRC case by Mr. Justice Humphreys, which involved the Illegal Migration Act and its disapplication here. So, one of the UK government's favourite arguments in this case, in these cases, seen particularly in the NIHRC, and I believe also Dillon, was this distinction that they draw between laws that are made applicable under the Windsor Framework and laws that are referred to in the Windsor Framework. The essential point of the argument is that the bells and whistles of EU law, if you like, the methods of interpretation, primacy, disapplication, charter applicability, all of that should only apply to those laws that are made applicable, not to the laws that are referred to. Now, this isn't a distinction pulled out of thin air. The phrases made applicable and referred to are found in Article 4 of the Withdrawal Agreement. But what this ignores is the second subparagraph of Article 4.1, which says everything in the Windsor Framework, everything in the Withdrawal Agreement that satisfies the conditions of direct effect in union law have direct effect domestically. This is not new. This has always been the case with EU law. Just because we've left doesn't mean it stopped applying, because it still applies under the text of the Withdrawal Agreement. Old rules, different packaging. That's all it is. So, this has been rejected in NIHRC by Mr. Justice Humphreys. Because, as we say, the Withdrawal Agreement told him to reject the argument. This isn't creative judicial application. There's no overreaching here. The text couldn't be clearer. The relationship between the ECHR and the Charter, Eleni, of course, went into detail about overlapping rights, and there is an important point here, both for content and in remedies, in terms of the way in which the two judgments, Dillon and NIHRC, appear to have considered the ECHR head of claim versus the Windsor Framework head of claim. Mr. Justice Colton in Dillon considered the ECHR and effectively almost adopted his ECHR reasoning into his Windsor Framework reasoning and held that there had been a breach of the Windsor Framework. In NIHRC, Mr. Justice Humphreys looked at the two separately. Is this a distinction with a difference? Not really, because the Charter in Article 52.3 says that where its rights overlap with those of the Convention, the meaning and scope of Charter rights will be determined by the meaning and scope of the Convention rights. So, rights guaranteed under the Convention are effectively, for the purposes of Article 2 of the Windsor Framework, also underpinned by the Charter. Where this matters the most is in remedies. I'll go back on that. If you're advising somebody who has had their ECHR rights breached, you might consider, if you can find an EU law hook, whether their Charter rights have been breached. Because if you have this choice between two different remedies, a declaration of incompatibility and disapplication, you're entitled to the stronger remedy, if Article 2 is satisfied. So, the removal element of the Spuck test, and this goes back to Section 5.4 of the EUWA. And the reason it goes back to that is because in Dillon, Mr. Justice Colton appears to have considered that Section 5.4, which says, as we saw earlier, the Charter is not part of domestic law on or after IP completion day, which is the kind of the implementation period following Brexit when it ended. This provision means, or is evidence of removal of EU law underpinning a Belfast Good Friday Agreement right, a crucial element of the Spuck test, as Eleni explained. But it's not quite as straightforward as that. Mr. Justice Humphreys in NIHRC said that 5.4 was subject to Section 7a, the conduit through which everything enters the domestic plane from the withdrawal agreement. And so for Article 2 purposes, the Charter continues to have effect despite what Section 5.4 says. But in reality, if you look at the whole of Section 5 of the EUWA, Section 5, subsection 7, I think, subjects the whole of subsection 5, or the whole of Section 5 to something called separation agreement law. Separation agreement law is further defined in the EUWA as including Section 7A. So this kind of circular-seeming drafting reinforces one key thing. Section 5.4 does not apply to actual, real EU law, including the Charter, that continues to apply here. I think the only way of reading Section 5.4 is by saying that it only applies to the part of domestic law in the UK that is no longer used to implement EU law. In other words, any domestic regulations that are no longer used to honor obligations under the withdrawal agreement or the Windsor Framework. That is the only body of domestic law to which Section 5.4 applies or could apply in order to preserve its meaning and not have it be completely useless. So it shouldn't apply to us, in this context anyway. So we would respectfully say that Mr. Justice Humphreys, therefore, is correct here. It doesn't matter so much for the purposes of the outcome in Dillon, because even if you look at the question of removal in Dillon and what the Legacy Act actually did, you have very clear evidence of the removal of underpinning EU rights under the Victims Directive, for example, and various parts of the Charter. But 5.4 isn't evidence of removal of those rights because it can't apply to those rights. So here's a little thought experiment for the future. The operationalization of the storm and break dropped when we were about finalizing the report. So for that reason, we don't really go into it in much detail. But what the storm and break does is it sort of divides the provisions of EU law in the Windsor Framework into two categories. Category 1, to which the storm and break applies. Category 2, to which it doesn't apply. Article 2 is safe. Annex 1 is safe. The break doesn't apply. But from Annexes 2 to 5, all of the common, or not all of them, but a lot of the single market provisions fall within the scope of the storm and break. What it allows us to do is consider X1 a provision of EU law that currently applies. X2 is a replacement provision. So the EU replaces X1 with X2. X2 is broadly similar, but improves upon, or changes X1. The storm and break allows the NI Assembly to say no to X2. So X1 continues to apply to us, X2 applies in the EU. Suppose during this fun time, the Court of Justice hands down a charter applicable or charter compliant interpretation of X2, or even strikes down bits of X2 for being charter incompatible. Because of its similarity with X1, in other words, it's a replacement provision, the language of this charter compliant interpretation could apply to X1. The question is, should it? The Windsor Framework doesn't give you the answer. There's no part of the framework that actually tells you what happens here, because the provision in the framework that actually talks about what domestic courts should do with Court of Justice case law is Article 13.2. The storm and break doesn't apply to Article 13.2. So, big question mark. And the reason why this is not just a fun experiment for academics, although it is fun, I swear. The reason why it's not just a fun academic thought experiment is because we have now seen the storm and break being operationalized in a few cases. None of them have been very controversial. I mean, in terms of what controversy looks like here. But it could, and it could result in protracted, polarized views that may not be resolvable at the joint committee level, which has a duty of resolving these conflicts if they come up under the storm and break. And if that is the case, then this may well become a reality. So it pays to think about these future questions before they arise, simply because when they are, or trying to deal with them as they arise, may not be a luxury afforded by time, or indeed the provision. So, with that, thank you very much for listening.
Thank you very much to our authors. I'm sure you all find that fascinating. I must say, even having reread the research yesterday and several times, there's still so much food for thought in there. I feel like we should all probably take a 30-minute break, lie down, come back. Let's have another go. So we have, I think we have about 20 minutes for questions, and then we'll invite our panellists and we'll hear from Hugh and Ty as well on the matter before the courts. So who would like to start? Come on now, don't be shy.
Do you want to get the three of them up?
Yes, please. Good point. Could you guys join us here for the questions? Thank you. Take your report just in case. Yeah, it's a good comfort blanket there. So we have a question in the second row there. One moment and we'll bring a mic to you. And we have a question in the back row as well. If you could say your name, please, and then put your question.
My name is William Love. I'm a concerned EU citizen by naturalization in the year 2000. Born in America, so I would have dual nationality. I'm married to a woman born in Northern Ireland who claims Irish citizenship. I've been concerned ever since Brexit was first discussed as to the diminution of my rights as an EU citizen in Northern Ireland. I believe there's been one test case of a woman and a man who are married who wanted to live in Northern Ireland, but he was told that he couldn't have settled status because he was American. I think I'm correct in that case. Has there been any other testing of the law since then?
As regards citizenship, protection of citizenship rights in
Yeah.
Northern Ireland after Brexit?
Yeah,
Okay,
protection of EU citizen
yeah.
rights for EU citizens living in Northern Ireland.
Yeah. So we'll-
As far as I understand, there's no requirement to apply for settled status for an EU citizen in Northern Ireland because of the Good Friday Agreement. Is that correct?
Yeah, that's a whole other area that we'd be happy to get into at another time, I suspect. So we'll gather that question, if you don't mind, and we'll gather another one or two and give people time to think about that. But certainly citizenship rights and under the settled status scheme, and that's a set of treaty rights that people have here, certainly, in addition to the no diminution protections that we're talking about particularly today. Each merit their own particular consideration. So we'll take Kevin's question as well from the back before we...
Yeah, Kevin Hanratty, Human Rights Consortium. Thank you very much to the authors for the wonderful report and look forward to read it in detail. I have a very, very poorly formed question and it's more exploratory because I don't know how to formulate it, so bear with me. I was fascinated to hear Tobias and some of the other contributors talk about the overlap between the Charter and things like the application of trade or the movement of goods, employment law across the border. The one aspect in terms of process post the Windsor Framework that is now going to be our next controversial element potentially is the democratic consent mechanism in the autumn, which covers the application of Articles 5 to 10, largely the trade aspects, north and south and single market. I just wonder, in the context of that vote and those articles in particular, how does the Charter apply to those specific aspects of the Windsor Framework, and in the context of potentially there being a vote to stop the application of Articles 5 to 10? Are we then effectively losing a whole area of EU law where the Charter would apply for those areas? I'm talking about the overlap between human rights and business and trade. And are we walking sort of almost blindly into an area where potentially there are huge sectors that are going to lose the access to Charter rights? And I suppose that's my poorly formed question, but that's a concern. That is that coming down the line? Is that a risk, or am I totally off the chart in that in terms of the concern?
Do we have a taker for that question before we move on? Or you want some time to think about that and we'll see if anyone else got another question?
Will I give it a poorly formulated answer? No, it's a great question. I hadn't thought about it. I mean, logically, and I'm looking at my co-authors there, if the democratic consent vote were such that these provisions no longer are applicable in Northern Ireland, then I would think that the Article 4 route would be closed as far as those provisions are concerned. That's the first step. There are two connected questions, and I don't know whether that was part of your question. Is the is the democratic consent vote itself subject to charter, procedural guarantees? Let's put it like that. Possibly, I don't know. The second one would then be, what would happen to somebody who would ordinarily, say, a company that would have a right to conduct a business under the Charter and rights to property under the Charter, following that democratic consent vote, could they then fall back on Article 2? Well, because, I mean, they could say, well, before Brexit I had this right, now I don't have it anymore. Well, I had it for a while after Brexit, but now it's gone. Tentatively, I would think yes, but that would be a massive. Imagine having to write that kind of an argument. It's like all these different steps. But I think that would probably be the case. But I don't know if anybody else wants to comment on that.
I agree with that. Especially in terms. Well, I think logically it makes sense. I mean, you would obviously struggle to say that it's a result of Brexit. Right. Struggle in the first instance to say that is a direct result of Brexit, given the time that has passed between. But I think eventually, yeah, you would be able to get there. I don't know if
the only thing I wonder is, after shall we say, a negative democratic consent vote that 5 to 10 should no longer apply here, there's, I think, a 2-year grace period or something, and then they stop applying. And that 2-year grace period is there to allow the joint, well, not the joint committee, but the EU and the UK to negotiate something to replace 5 to 10. Short of magical unicorn Brexit thinking, I don't know what would replace those. And so unless we are talking about a very different set of provisions where it's not single market inclusivity, but rather a hard border between North and South, so soon after that was completely rejected, I don't really see any alternative to the current arrangements. So I suppose it's a long-winded way of saying I can't really see, at least in the near future, the complete loss of charter rights over single market provisions, because I just don't see what you would replace those provisions with. It might come back as the same provisions in another different package. Who knows?
Have we any other questions from the floor just yet? While you're thinking about it, sticking in the trade area, but maybe just moving towards employment, I think is something that's slightly closer in terms of the human rights arguments we can make slightly more easily, So I would be interested, I think, Eleni, you mentioned the interesting line of cases in regards to employment law, because I think we can more easily make the stretch to the Belfast Good Friday Agreement in terms of equality and civil rights, embracing employment rights. And of course, as you said, the UK government has acknowledged parental leave and part-time working and so on. So can you maybe set out for us in a bit more detail how that would work to construct an argument before the court as regards employment law and how we would use the directive, look to the agreement and then the relevant directive and then bring in the charter to try and bolster the argument of how that could benefit us, really?
Thanks. Yeah, so that's a really good question. I mean, it depends obviously on where the hook is. So
Yeah.
if it's in the Annex 1 directives, for instance, that's a fairly, I mean, there's a fairly easy link to the Charter, but there's also, I mean, a fairly easy, I would say, now based on recent case law link to certain provisions like Article 47, which make rights more effective, also in I suppose, private law contexts. So we've seen, for example, Article 47 being used in a race discrimination case, the Brathens case, which concerned a settlement between an airline that had racially discriminated against somebody under contrary to the Race Equality Directive, which is listed, and an individual, and there was no. It's an interesting case because the argument of the individual was that there was no symbolic acceptance of discrimination in the payout. So basically, the airline was paying, but they weren't acknowledging that they had discriminated. And the European Court of Justice said, "Well, hang on a minute. No, actually, you can't do that under the Race Equality Directive. The directive itself says nothing about what kind of remedies you need to give." But the court read into it through Article 47 the right to effective judicial protection, a need to actually embed in discrimination claims of this nature, in discrimination payouts, if you like, as a symbolic dimension. So, for example, a judicial finding that discrimination had occurred, or an admission of guilt, or something to that effect. Otherwise, Article 47 of the Charter would not be fulfilled. So that would be that could be an easy, a kind of I think an imaginable scenario in several disputes with employers, especially. The kind of settlements people reach, or also judicially or extrajudicially. Another one could be, how you read certain employment rights which aren't listed. So, the more difficult cases, I suppose, come in situations that aren't within the listed directives, but are within fields that touch upon equality law, or that touch upon other safeguards that could notionally fall within the RCO section. So, for example, you could think of the right to paid annual leave, which is a right protected in the Charter under Article 31 of the Charter, which is not protected in any of the directives that are listed. But you could say that this is a right that, for example, enhances say equality, that enhances family life, that enhances various other political rights which fall within the RCO section. And so, you could find a hook through those to link back to the case law on the more concrete employment rights, which are often also of a financial nature. So sometimes there will be obviously additional pay because of loss of leave, or even just restitution of the thing itself. So you would have the right, prospectively, and the right guaranteed, obviously, for all other applicants in the same situation. This is, off the top of my head, two situations that I imagine basically coming up fairly easily. One more concrete and direct than the other, but both, I think, imaginable.
And both showing the added heft, I suppose, where the directives are often brief or silent on the detail. That we all need to look across to the Charter and then look across the case and see what else can we read across to bulk it out a bit and substantiate. So fascinating. Where are we now? Who else has a question? Have we any online, Lisa? No, not online. Okay, everyone's heads are just too full of thoughts. There, Kieran, there.
A question primarily for Elena, because it was triggered by her slide, but I'd be very grateful for Tobias and Anurag's view as well. Kieran White, Ulster University. Elena, Article 35 of the Charter is the right to access healthcare. Now, that wasn't in your list of rights that you considered, if you like, come through what I call the gateway provision in the BGFA rights. So I suppose my key question, and it's for the whole panel, is, well, if not, why not? And, what is it about the right to access healthcare that would not have been anticipated or included or imagined to be part of the bundle of rights to which, in particular, the Article 2 non-diminution guarantee applies?
Yeah, that's a brilliant question. I mean, the short answer to it is, I think, simply that the list was not intended to be an exhaustive one. Actually, you make a really good point. I mean, yeah, why not healthcare? Of course, yes, healthcare. I mean, of course it contributes to equality. Of course, it contributes to equality of opportunity, especially. So, sure, yeah, it could be. However, I think perhaps the reason why we didn't say very much about it is also that, I mean, healthcare is an area of review, especially in cross-border contexts. There isn't any case law really on healthcare as a human, at least that we've seen, and correct me if I'm wrong, Tobias, for healthcare under the Charter, as a self-standing right, it has generally not been litigated under the Charter. So, and the case that we do have, like Waltz and similar cases, that has been about cross-border services. So it hasn't. We don't have as much support, I suppose, for the additional contribution that the Charter makes to this field. But that's not to say that it wouldn't have a contribution or that that it can't do. It's just that that so far, at least, the case law hasn't really hasn't beefed up that provision on healthcare specifically. And
maybe maybe to thanks for the question, which I think is great. One thing we didn't mention, and maybe we should have, is obviously that the Charter makes this distinction, which is not fully understood yet, between rights and principles, right? It's hidden away somewhat, and it was only introduced at the last minute when the Charter, shortly before the Charter was meant to become binding. And the member states got cold feet. And they thought, oh, there's all this social stuff in there. That's going to cost us a lot of money, so let's make sure we're not bound by it. And so they said, well, some of these things are not rights, they're only principles. And principles meaning that, the legislature has to kind of strive to fulfill those principles as best as they can, but we can't have an individual claimant coming to us and say, well, my healthcare is bad, I have to wait for 18 months to get my hip replaced or even longer. Therefore, I've got a right to good healthcare. And Article 35 is one of those provisions that are mentioned as principles in the Charter explanations. Now, the Court of Justice hasn't been very brave on principles. There's one decision which we discuss in this report called Glatzel about Article 26, which is about the integration of people with a disability, where the Court of Justice was not very brave. It just said, well, whatever the legislature does with it is basically what the principle means. So it's a kind of, bit pointless. I think it's somewhere they could still go. They haven't been pushed very hard, as far as I can tell. There hasn't been any other case law. And obviously, I think now it's something I only noticed last week. So maybe it's not, don't quote me. Well, quote me, but, tell everybody, if you're quoting me, just say he doesn't really know what he's talking about yet. But what I could imagine is that the Charter could be invoked, Article 35, for instance, in conjunction with the right to an effective remedy. So you might say, well, I don't know, I might be suffering, from. I'm not getting access to good health care. That might not be a right in itself, but I also can't do anything about it. Yeah, and so you're kind of in the scope of the Charter, but there's no remedies. There's nowhere you can go because you're at the hands of the NHS or something. And they say, well, you're number 172, and that's you wait until it's your turn, and that's it. No remedy. That might be a way in, maybe. I mean, I think that's where the Court of Justice is most likely to move at this stage, perhaps. But it's obviously very difficult it's much easier to litigate in a jurisdiction like Northern Ireland when you've got settled case law from Luxembourg, because you can say, look, I mean, this is what they're saying, we should be having the same thing. It's much harder to litigate in a situation where your court cannot ask the ECJ for a preliminary ruling, because that's been excluded with regard to Article 2, and tell them, well, you now be brave on developing this particular area of EU law, which is not really your thing, right? And push the boat out. So I think strategically it's probably better to wait for things to be happening in Luxembourg and then importing them into here. But that's just a bit out on a limb, but I think we can go out on a limb a little bit in the discussion here.
Yeah, we're here to go out on limbs for this afternoon, yeah.
Just one point I'd like to add to that is in both the Dillon and the NIHRC GR295 cases, there's a bit of the Rights, Safeguards and Equality of Opportunity chapter in the Belfast Good Friday Agreement, which both judges focused on quite heavily. And I certainly was pleasantly surprised that they did so, because it always struck me as a preambulatory bit, that beginning of the chapter which says civil and political rights to everyone in the community. That bit always struck me as preambulatory. But both Mr. Justice Colton and Mr. Justice Humphreys located rights within that bit, and it's kind of general and all-encompassing. So that could itself be a source. I mean, it's obviously not an EU law source per se, but it could be a source of rights beyond the specific list in the RSCO, to which corresponding charter rights can attach. It would take an extremely brave High Court to do that, though. We'll see.
And just to plug the Commission's research by Tammy Harvey on this, one of the early pieces the Human Rights Commission contracted for was to look at whether and to what extent the right to access to healthcare could be read as falling within the relevant chapter of the Belfast Good Friday Agreement, and thereby to what extent it would interact as a consequence with Windsor Framework Article 2. And we did, in that piece, rely heavily then on the commitment to civil rights and religious liberties of everyone in the community. And we also did, the Commissions have looked as well to consider to what extent that broad commitment to civil rights should in fact be understood as recognition and acceptance by the signatories to the Belfast Good Friday Agreement of all the body of international standards to which the UK was signatory, and potentially even on an ambulatory basis. So that is a route to recognising rights to healthcare within the Belfast Good Friday Agreement. But then to look across to the underpinning EU law is the next step of the challenge, and to look at to what degree, if you're trying to make a case for diminution, to what degree you could demonstrate then that such rights would be diminished, as opposed to defunded or other issues. We have a question from Hugh.
Actually, it's more of a comment. It's more of a comment towards the last point, because I just wonder, it was interesting that, Tobias, you mentioned a case about persons with disability, because, of course, there is plenty of EU law. And, in fact, I have a case up for permission on the 3rd of October, disability action, withdrawal of funding to disability action. And we're running Windsor Framework questions, but it's in that context of disability, an organisation which is devoted towards enabling disabled persons to fulfil their potential in society. And so, that's the sort of case, I think, where, there can be a crossover towards healthcare, because general access to healthcare, tricky. Access to healthcare for somebody who is otherwise a person with a disability, that's a much stronger proposition, I think.
Just what we need to be thinking about is, how to construct the argument and what's the strongest, and potentially whether certain arguments will become easier to make down the years as we anchor some of these current live issues before the courts. So we've run out of time for this session, but it's all part of the programme is all connected anyway. So we're now going to look at the EU Charter from the perspective, and I'll ask our panellists to stay with us where they are, and we're going to hear from Tai Wynn, solicitor at the NIHRC, and Hugh Mercer, KC, and their experience to date and attitude to running cases involving the Charter. So just to introduce both, before, and then I'll ask you to come up in turn and then join us there for discussion. Hugh has extensive experience at appellate level in the courts in England and Wales, in the CJEU, and before courts of other countries. He also practices in Northern Ireland and in Brussels. His public law work encompasses public and regulatory law, Brexit, including the Windsor Framework, human rights, public international and investment law. He chairs the International Committee of the Bar of England and Wales and holds a number of other senior legal roles. Ty is a solicitor with the Commission who has had carriage of our own motion challenge to the Illegal Migration Act 2023. She also has experience of intervening at the European Court of Human Rights and will be appearing at the UK Supreme Court later this year. Ty's previous work includes representing families in a number of high-profile public inquiries and working as a solicitor to the inquiry into hyponatremia-related deaths. So Ty and then Hugh will join us to give us their remarks first and then join us for some discussion.
Good afternoon, everyone, and thank you for staying on, especially those online and listening to the next part of the launch. And for those online, we can't see you, but we do know when you're on your phones and not listening. I can't really add any more to the excellent research that has been done today and presented, so I just want to give a few practical aspects of anyone contemplating proceedings under Windsor Framework Article 2. So just a quick overview of what I want to speak on. So I'm just going to address issues such as standing and leave in a judicial review and hopefully give some practical considerations for anybody in pre-action correspondence and perhaps what to put in the Order 53. So a challenge under Article 2 of the Windsor Framework is brought by way of judicial review. And the reason I want to just talk about standing is people in the room and online may be thinking, who can bring a challenge under Windsor Framework Article 2? So it's different in terms of standing that people may be familiar with under the Human Rights Act, where there's a requirement for victim status, especially under Section 7. For the purposes of a judicial review here, what is required is that a person or an organisation should have sufficient standing. And that's set out in Order 53 of the Rules of the Court, and that's mirrored again in the Northern Ireland Act 1978. So they state that applicant has sufficient interest in a matter to which the application relates, and the courts have interpreted that quite broadly, so that can encompass personal standing and also representative standing. So that's where a claimant group could bring a claim where they represent a section of society or the public interest. Now, in terms of what does sufficient interest mean, so if we turn to Lord Reid in the case of Walton and Scottish ministers, so that's a 2012 case, but it's still good law, and that makes reference to someone who is not a mere busybody. So if we turn to paragraph 92 of that judgment, Lord Reid describes a busybody as someone who interferes in something which they have no legitimate concern. Obviously, we would never know anyone like that. And it also sets out again that it really depends on the facts of the case. So no one should really be put off thinking that there's a high threshold to bring a case under Article 2. And also we remember that it has been set out in recent judgments that the civil rights in the Good Friday Agreement do apply to everyone in the community. And standing, again, was considered quite helpfully in the Court of Appeal in Northern Ireland. And again, the Lady Chief Justice just set out there that each case is really dependent on the facts itself. So once we've addressed the issue of standing, the next thing applicants will want to look at is what's the test for leave. And the test for leave to bring a judicial review is an arguable case with a realistic prospect of success. So in your pre-action correspondence and your Order 53, you would really want to be addressing the test that was set out earlier today in SPUC, so that 6-part test. I don't want to go through it again, but that's what the courts will be expecting everyone to address, and it's really important, which we will see in the Eshmal case, which I will go on to later on, that the underpinning EU law, that's part 3 of that test, it's really important that that is referenced and set out and linked to, and it's not just an abstract reference to a Good Friday right or an ECHR right or a CFR right. So just going to the first case, which is the Illegal Migration Act challenge. So as everyone knows, that was a case that the Commission brought using our own motion powers. Here the IMA was challenged based on various provisions that were contained in the EU asylum acquis that the UK government had signed up to prior to leaving the European Union, and the Commission successfully challenged that various provisions in the IMA were a diminution of rights contained in that those EU law provisions. And Justice Humphreys there in that case, so it's really worth reading for anybody who is considering this type of challenge. He helpfully set out how the withdrawal agreement, Windsor Framework, Section 7 of EUA, and the Charter of Fundamental Rights, how they all really came together. And in particular that he confirmed civil rights do extend to everyone in the community, and that the Charter continues to have effect in Northern Ireland. So we've already had a really great discussion, helpfully set on remedies, and if you are considering bringing a claim, you may be considering, well, what's the difference between an Article 2 challenge or a challenge under ECHR if you've got very similar grounds. And as has already been set out, something to consider is actually what the remedies are that are available. So under Article 2, if there is a breach of Article 2, then the remedy itself is a disapplication of that offending provision. So what happens then is that the provision stays on the statute book in Northern Ireland, but it's just disapplied with respect to Northern Ireland. So that is a really powerful remedy compared to something where there is a breach of ECHR, where you get the declaration of incompatibility and you're then waiting for Parliament to then legislate and rectify that incompatibility. So that confirms the supremacy of EU law. The other thing that I just want to draw attention to, and again, that's already been mentioned, is Article 47, the right to an effective remedy. Now, this can be quite a useful part of any grounds of challenge, particularly if an Article 6 ECHR ground may not be forthcoming. There's quite an overlap there. So, for example, in the IMA case, Section 54 of the IMA prevents a court or tribunal from granting an interim remedy to delay the removal of a person from the UK under that Act. And the High Court held that that particular provision led to a diminution of Article 39 of the Procedures Directive, which provides for asylum applicants to have an effective remedy before a court for certain decisions made about them. And that was a diminution in conjunction with Article 47. So turning to a very recent case, a quite important case of Eshbal. So this particular case was again centred on Windsor Framework, Article 2. The applicant here was a citizen or is a citizen of the United Kingdom. They're originally from Sudan and they wish to secure a safe route for their family members to join them in the UK, similar to the Ukraine scheme that had been set out. And the applicant argued in this particular case that her right under the Good Friday Agreement had been breached pursuant to Article 2 Windsor Framework for not having this particular safe route. What's interesting in this case is that the applicant based the challenge just on the Charter grounds. So we see here human dignity, right to life, right to liberty, etc. So very similar overlap to some of the ECHR grounds that we would be familiar with. But they didn't make any reference to any particular grounding or underpinning EU law right. So in this particular case, Justice Humphreys dismissed this challenge. And we see firstly, just in his statement, in his decision that he has set out, he was very critical initially of the lack of analysis of how these rights were breached within the evidence provided in that case. And that is really important as part of any judicial review. There has to be supporting evidence in the form of either affidavits, documents, official statistics, or other reports to support any grounds of challenge. He's also very clear in this judgment that the Charter The rights are not freestanding rights, so they can't be litigated upon within the confines of Article 2, as they only apply where EU law is being implemented. Also important to note that the Good Friday Agreement does not give effect to charter rights domestically separately to Windsor Framework Article 2, so there has to be an underpinning EU law right, and he states here that in the absence of any EU law source being identified, the claim fails. So moving on to a more positive note of when and how a charter right could help a Windsor Framework case. So I'm referring now to a case, very recent Irish case brought by the Irish Human Rights and Equality Commission. Even though that's in Ireland, there's no reason why this line of reasoning and argument couldn't be applied in Northern Ireland. So this is a case brought by IREC with regards to the state's failure to provide adequate accommodation for people seeking international protection who had arrived in Ireland. This case concerned the 2013 Reception Conditions Directive, which established minimum standards of living conditions for asylum applicants. Just to remind everyone that NI is subject to a previous incarnation of this directive from 2003, but the provisions are still very similar. So under this directive, when a member state receives a person seeking asylum, Article 2 states that they have to be received with conditions that include housing, food, clothing, other financial allowances, etc. So the Irish Commission went on to argue that the minimum standards set out in this directive and transposed by their national regulations expressly intended to ensure full respect for Article 1 human dignity and other relevant charter rights that were applicable. So this case really centered around the definition of basic needs. Although the term basic needs aren't defined in the directive itself, member states must provide for them, and the elements of what a basic needs are have been described by CJ EU case law, particularly in the cases of Securi and Hackbin. So Securi, incidentally, did actually refer to the 2003 directive, which the UK is bound by, and that set out that Article 1 of the Charter, that human dignity must be respected, protected, and it stops the asylum seeker from being deprived of the protection of minimum standards under that directive. Hackbin then found that those directive provisions, read in light of the Charter, meant that a member state could not withdraw or reduce material reception conditions, even on a temporary basis, if that would have the effect of depriving that person of meeting their most basic needs. So, and again, if anybody who reads this decision, it's quite lengthy, and a lot of it is dedicated to the standing of the Irish Commission, which we're not concerned with today. But what is really interesting in that case, and what's really helpful, is that the court really placed a lot of value on the evidence provided by IREC in the form of numerous supporting affidavits and case studies. So again, just to emphasize how important it is that any person considering a challenge really evidences the grounds of challenge and the remedy that you are seeking. So the court's decision then was that it went on to hold that by failing to meet the basic needs and leaving applicants who have applied for international protection without accommodation or the means to access accommodation, the state had breached the rights of those persons as provided for in Article 1. So again, the Irish court confirmed that a failure to provide for basic needs of applicants did amount to a breach of their right to human dignity. So that's just my talk for today, and I hope there have been some helpful pointers for anyone considering litigation. And I'm going to hand over to Hugh Mercer now, and we're very lucky to have Hugh today. Hugh acted for the Commission and the Equality Commission jointly in our intervention in the Anguisham case, which really set out the scope for Article 2. And he has also provided numerous legal opinions for the Commission and has really driven the way forward for the legal team in the Commission in how to apply Article 2. So we're very grateful for Hugh for coming today.
Well, first of all, Ty, thanks very much indeed for your kind words of introduction. It gives me great pleasure to be with you today on the launch of what is a truly excellent report. It's the sort of report which I will be digging into for many a month into the future on my cases. I confess, unlike others in the room, I haven't read the whole of the report yet, but I will be drawing on it, I know, in the case law and looking at the analysis, because, of course, it's an area where we are all feeling our way. You know, it's one of those areas where, at the moment, members of the bar, I work with a lot of members in the bar library here in Belfast, and lots of cases. Windsor Framework is pleaded, and it's a question of trying to work out. You know, when we sat around the table thinking about Angusum, you know, what do we think about this? How far can it go? You know, can we produce something useful? Is it worth intervening on it? Because it was always, in a sense, going to be a difficult case, because removal from, or dispersal, if you like, of an asylum seeker from Northern Ireland to Scotland, in principle, it's difficult to see how that comes within the relevant part of the Belfast Good Friday Agreement, or how there is a right which is grounded in EU law, which prevents a member state. You know, if that would work in the UK, it would also work in Germany. So somebody who arrives in Bavaria could not be transported to Rheinland-Pfalz if there were more accommodation in that particular land than there were in the other. So I've really been asked to make some practical comments about on the Windsor Framework aspects, especially for how to ground the argument on EU measures. I think I'd just like to make one other point about the report before I leave it. I like the way in which, particularly in the summary and also through parts of the report, you stress the element of comparison, which is inherent within Article 2 of the Windsor Framework. Because diminution necessarily is looking at, you know, position A and position B. And so obviously, clearly the relevant right must be within the scope of EU law, and you must be located within the relevant section of the Belfast Good Friday Agreement. But once you are there, in a sense, the underlying question is, before Brexit, would you have won? Because if you would have won before Brexit, then you ought to win after Brexit. That's what non-diminution. I mean, because when we're dealing outside Annex 1, Annex 1 obviously is dynamic alignment. When we're dealing with the mainstream Article 2 aspects, you're dealing with essentially what is, in public international law, the well-known version of the standstill provision. So you've got a level of protection which is there, and however the protection is formulated, whatever, the UK can reformulate the protection, can put it into different instruments, that's not the problem. But you've got a bar which you can't go beneath following Brexit. So we've got some emerging case law, and the difficulty, let's say, for practitioners and judges, is working through which out of the multitude of cases where the framework is pleaded, in which it should make a difference. And I mentioned Angusum, I won't go back to that. I mean, you know, in the Troubles amnesty case of Dillon, when the Human Rights Commission and the Equalities Commission decided to intervene and applied to intervene, to be honest, the case on the Windsor Framework was relatively inchoate. You know, it was raised as an argument, but the argument wasn't really carried through to its logical conclusion, which is that, you know, the big difference, as has been stressed, is that if you've got the convention right, make that good, but if you can get the charter right to work, then you've got the range of remedies available under EU law. There's one aspect of the report, actually, where this notion that consistent interpretation has been, in a sense, the poor relation of disapplication. The case I think about on that is autologic. Lord Nichols, in about paragraph, I think, could be about 16, 17, I think, of the autologic judgment in the House of Lords, where he says that the duty of the National Court is to mould, to set aside or to mould national law. But perhaps what comes out of the case, which I think Eleni mentioned, is it's across the whole area of the law, which is quite an extensive, which is, you know, potentially a very extensive obligation. What instrument could you be moulding creatively in order to make the right effective? of course, in Dillon, I think the big thing which the Commission's brought to the case was to put forward the Victims' Rights Directive, in particular Article 11.1, the right to review of a decision not to prosecute, which is, when one thinks about it, a right to a review of a decision not to prosecute is there's a similarity of that sort of provision with Article 47, which provides, and Article 47 and necessarily Article 11 of the Victims' Rights Directive must operate in conjunction with something else. So it's a right to review of the decision not to prosecute whom for what. And once you find yourself saying, well, it's a right to review a decision not to prosecute somebody for murdering your husband or son or whatever, or for torturing your relative, then obviously the scope or the potential scope of Article 11.1 should be apparent. Obviously, we're going to find out next Friday. We've just heard today that the judgment in the Court of Appeal in Dillon is coming out next Friday, and so we will read that with interest. I think the difference I found between the Dillon judgment on the one hand and the IMA judgment on the other, the Humphreys judgment, is the way, first of all, Mr. Justice Humphreys' judgment was such a clear analysis. Of course, he had available to him Mr. Justice Colton's analysis, so he could then sort of sit back and draft it in his own way. But I think Mr. Justice Humphreys, he went through, so here's the provision of EU law which is relied on. Here is the section of the Act which is relevant, and in what way has the Act diminished that EU right? So he went through quite sort of step by step, whereas Mr. Justice Colton was more broad brush. This is within the scope of the Victims' Directive, and I've decided that the ECHR provisions are breached, and therefore the CFR provisions are the equivalent of the ECHR provisions, and so I'm home. And that's something which I suspect, I certainly feel from the questions during the hearing, that the Court of Appeal is going to be rather more prescriptive on that. Reflecting more specifically on the role of the Charter, I think that the scope, despite the decision of Mr. Justice Humphreys in the summer in Shima Ismail, which I think essentially is a case which failed evidentially. I think I agree with Ty on that. I'm not sure we've really fully exploited the scope of CG against the Department for the Communities. Because there, the UK had gone further than required by EU law by granting a free right of residence. So that in accepting the claimant, the UK was acting within the scope of EU law, fair enough. But on one view, the grant of the right of residence exhausts the EU content. And the fact that the claimant then, once in the UK, is then destitute is arguably separate. I say arguably separate, but the Court of Justice, is the way in which they invoke the Charter is not wholly clear. In Shima Ismail, Mr. Justice Humphreys says, well, clearly the CFR was being invoked in conjunction with the right of movement. And so that's a classic application of the Charter. But when you read the Court of Justice judgment, it's not that clear. As I say, on one view, once you've moved and been accepted, then your free movement right is exhausted. To say that once you've moved to another country, that therefore everything which follows from that is still within the scope of EU law right and can be fixed by the application of EU law in conjunction with the Charter right, that is quite far-reaching, I feel. And so, in a sense, I feel that what is not answered by the Shima Ismail decision is how far the exercise of such a broad anchoring right, such as the right of free movement, might extend. This reminds me of the debate which took place in relation to the Sunday trading and B&Q going to the European Court of Justice to challenge the ban on DIY stores being open on a Sunday. It was alleged to restrict their EU law rights because B&Q sold lots of imported goods, and there would be less imported goods sold if their shop were closed on a Sunday. And initially, this had a modicum of success. And it took time for the CJU to draw a line to distinguish between, on the one hand, conditions of sale of products with a sufficient nexus to importation, and on the other hand, other general conditions of sale indistinctly applicable to all products. And so, I feel that is, the nexus. I feel that the Court of Appeal is likely to give more specificity to what sort of a nexus you need between your EU law right and how you've got your anchoring right, but how far your anchoring right extends, basically. And as I mentioned in the comment, I should finish because we were asked to speak for 10 minutes, but just in the comments, I mentioned this disability action case up for permission on the 3rd of October. We will see. It's a case challenging the withdrawal of funding for an organisation devoted to enabling and assisting persons with a disability to achieve their full potential. Much EU law is relevant to persons with disabilities, and disability action is an important part of how those directives have been rendered truly effective in Northern Ireland. And so one might regard it, in a sense, as part of the full and effective effect, part of the principle of effectiveness, rendering the directive effective. So with those few thoughts, I'll happily participate in the discussion. Thank you.
Thank you very much, both Hugh and Ty, and every day's a school day, honestly, listening to you people. So I'm sure you've got lots of questions for each other. My initial thoughts were it'd be useful to hear from you all a little more exploring the issue of remedies. Interesting to hear a bit more from you all, maybe on your thoughts on where, we've touched on where Charter Article 47 takes us, but some reflections on where that has led to in certain cases. But open to thoughts on what you would all like to talk to each other about as well. So where shall we start? We're looking to you guys to lead this rather than the audience. So would you like to maybe start with the remedies point then, in terms of how significant that is in particular, in terms of what the Charter brings to the table, in terms of, we're used to thinking about it, and as Hugh mentioned, the issue of disapplication deriving in both the cases recently from the reading of direct effect of Windsor Framework Article 2, but of course the Charter is bringing this remedy itself to the table. So perhaps I might ask Tobias to start there.
So I'll just throw something in. Because Eleni mentioned the Bratton's case, Bratton's aviation case, which is actually quite interesting because it's a fairly simple. I mean, it could happen here very easily in terms of the facts. We had an individual who was racially discriminated against by a flight attendant on a flight. The individual then complained, or sued the airline. The airline then settled out of court and paid a compensation. And under Swedish, and it was a case set in Sweden, under Swedish procedural law, that ends the case. What the individual did not get but wanted was a formal declaration and admission by the airline that the claimant had been discriminated against, racially discriminated against, which is, of course, an important factor in that kind of case, because it's more about the humiliation suffered rather than receiving some sort of payment. You also want the recognition. But that remedy was simply not available under Swedish law. Swedish law said, well, if the case is settled, that ends, the court's jurisdiction ends here. That's it, end of the story. And so the Court of Justice heard the case, and it said, okay, Article 47 of the Charter applies, obviously, because we're in the scope of EU law, because we're dealing with the race directive, Directive 2043. And Article 47 of the Charter means you have a right to an effective remedy, and not having that recognition means you're denied a right to an effective remedy. But it has far-reaching repercussions for the national legal system, because the national judge now has to order something they don't actually have the power to order. And I think that is something, I mean, it's obviously something that's very difficult to translate into another legal system one-to-one, because every legal system has its own limitations in procedural terms. I mean, in the UK, obviously, we have factor tame, which was the first that type of case where it used to not be possible to get an injunction against the Crown, and the Court of Justice said, well, you have to do it. Always careful to say, well, you don't have to create a new remedy, but you have to apply existing remedies to new situation, which, you know, is kind of a interesting distinction. But anyway, that's the semantics of it. So I wonder, and maybe others on the panel have thoughts about this, how this Article 47 trick could be pulled in Northern Ireland, or in you know, or in the Supreme Court, indeed, and how they would judge that potential.
Yeah. Yeah, I mean, that's really interesting. I hadn't really followed the detail of the Brathens case. I mean, obviously, the first thing you do as an advocate for that sort of thing is to look really closely at the rules, the national rules. You know, so, and of course, it's how they're formulated, because the EU remedies are fashioned in the context. They're supposed to be applied in the context of the national rules in principle. So your starting point is, you know, you look at. So does the rule say? You know, once there's been payment of damages, the case is forthwith terminated, and how do you read that? Because a lot of, you know, whenever I've done these cases on consistent interpretation, the first thing the judge asks for when you come into court is, so what words are you reading in? You know, you go back all that time to the Lidster case, which I noticed is cited in your report. Lidster and Fourth Dry Dock is my sort of stock case on you know, the scope for a consistent interpretation. It was transfer of undertakings regulations, and it said that you were entitled to the benefit of the regulations. I'm paraphrasing, but if you were employed by the relevant company immediately before the transfer of the undertaking. And so this practice emerged among creative commercial lawyers of sacking everybody an hour before the undertaking, the transfer of the undertaking, saying, well, in English law, immediate means a sort of millisecond before. It doesn't mean an hour before. So if we sack everyone an hour before, we'll be scot-free. We'll get off scot-free. And so Lord Templeman in the House of Lords said, no. A consistent interpretation means what it says. Here you're trying to defeat the purpose of it. So, in fact, what you must do, you must read the regulation as if it says, was employed by the company immediately before the transfer, or would have been so employed if not dismissed in contemplation of the transfer. And all those additional words were added in. But you know, as an advocate, that's the most difficult bit. You know, looking at the sort of the interlocking rules of local procedure, because I've done cases in various countries around the EU, looking at the rules of procedure, and then trying to sort of, you know, test and game which one is the most likely to be able to be, you know, to sort of have some wiggle room in it, or to be able to be read in such a way to be creative. Because I mean, Lidster was, you know, really creative. But if you try that at first instance, you get knocked back. It's not till you get to the House of Lords they've got a confidence say, yes, you know, we'll just sort of basically rewrite it a bit. So no, and I think it's interesting. I suppose that your report must go into. I haven't gone into the factor tame aspects, because that's another interesting aspect. You know, you've got the fact that obviously there's express provision that the charter is over, but the charter isn't over. You've got express provision that factor tame is finished, and there will be no more factor tame damages. But I think from your research, you suggest that comes back as insofar as it's necessary to provide an effective remedy. I think that's interesting. That would get the bar going here.
Yeah, so I mean, it is. We were actually really fascinated by this, because we always get this question about state liability and damages, and it is something that really gets people going in the UK. And It fascinates us because we actually tried to look up the number of cases that resulted in state liability and damages. And obviously, there's a lot of commentary on this. A lot of them get settled before they actually go to court because the government doesn't want them going to court, I presume. But it is interesting that this creates so much debate. Yeah, but of course, in terms of European constitutional law, the right is, in a sense, considered almost coextensive with a remedy. So we don't have the separation of sort of the existence of the right and the remedies treated separately. So it's an interesting, it's an interesting difference between the, I suppose, more civil law culture of the European Court of Justice, perhaps, and then maybe the domestic culture. I don't know. We were quite interested in this. Yeah, for us, state liability and damages obviously has to be there, considering if it isn't available, and it would have been before Brexit, there will be diminution.
I suppose the big difference for us is that state liability and damages is very limited under English public law. And so you've got to be able to interpret the statute as if it necessarily gives rise to a right to damages if there's a breach. So it's, as I understand it, and Tobias would obviously correct me, but under German public law, for example, if there's a breach of statute by a state officer, in principle, if the relevant conditions are fulfilled, it can give rise to a right to damages. So that for us, state liability is quite revolutionary. I don't think they can put that too high, because the number of times you get state liability outside the area of EU law is very, very low. The courts are very protective and anxious not to chill, they would say, the state. Except on the other hand, you've got tough cases where individuals suffer at the hands of the state and get no redress, which doesn't seem right either, because the state, after all, is aggregating the loss among the whole community. And if the state's made a mistake, then it would seem more logical that that might be the result. But it's something that is, we have an ingrained suspicion and resistance to it.
Yeah, that's correct. I think most continental legal orders will have a state liability provision somewhere in their civil code or in their public law statutes. So one thing I was interested, it's the duty of consistent interpretation is obviously, is a very magical tool for a judge, because it's actually better than disapplication in many respects, because you can, just reinterpret the law and order the remedy that you want to give, right? As a result, which is a great power, but it's obviously designed from an EU perspective to interpreting statute. But what about the common law, which obviously contains a lot of the law in Northern Ireland? How do you deal with that? That's is a genuine question, but statute, the duty of consistent interpretation, maybe charter consistent interpretation, and common law rules.
I think, well, in my head, logically, if you use any part of your domestic legal order to implement an EU obligation, that is subject to the duty of consistent interpretation, no matter what its source is. That should be the straightforward principle. It sometimes isn't, but that should be the principle, I think.
I totally agree with that. If one thinks about it, if one goes back to the fact of the Mar leasing case, the Spanish case, where an EU directive set down about 10 different bases on which a company, the formation of a company, would be unlawful, or I think lacking cause, and no, it would be unlawful. That's right. And in the Spanish courts, it was pleaded that in fact there was an additional, almost semi-common law principle going right back to the formation of civil law in Spain, the idea of sufficient cause in a contract, in this French sense of cause, that this was an additional basis on which a company could be found to be unlawfully formed. But the Court of Justice there, that's really the case I always go back to on consistent interpretation, held that there, because the 10 bases for the illegality of a company were set out in the directive, because there needed to be legal certainty with regard to these bases. They were the exclusive bases on which the formation of a company could be impugned. And therefore, Spanish law must be read subject to, or must be read to have been superseded by the relevant directive. And therefore, this broad general principle of contract law, which as I understand it is pretty fundamental in the civilian notion of the contract, was set aside in the specific context of company law.
I want to sort of look at or mention very briefly one aspect of remedies that I feel like has degraded quite rapidly and quite alarmingly since IP completion day. The question of remedies under EU law, disapplication, primacy, so on and so forth, applies not just to people you're advising under laws enacted, it applies to the enactment process of laws, because it's something that you should, as a legislature, for example, think of, or as a government department moving a bill, think of, in the same way that statements of convention compliance are thought of by ministers moving a bill. This complies with the convention, for example. That was part of parliamentary practice, and I think a large part of the sort of advice given by law officers and GLD and so on and so forth before. And since then, the European Scrutiny Committee, for example, is no more. So there's no one single committee in Parliament that looks at, or in the House of Commons that looks at bills or secondary legislation from a perspective of whether or not these comply with EU law. And in terms of the Charter specifically, the JCHR, the Joint Committee on Human Rights, doesn't look at it. And you saw this to devastating effect during the passage of the Legacy Bill, because the Human Rights Commission made repeated points to Parliament that this would breach guarantees in Article 2. The JCHR didn't look at the Charter. The Legacy Bill, I think, was considered to be a bill of constitutional significance, so its committee stage was taken, its main committee stage was taken on the floor of the Commons. One MP talked about the Windsor Framework, and that was Stephen Farry. He didn't get an answer. He mentioned the words. That's it. That's the whole Hansard record of the bill. And the outcome was Dylan. So there's a, I don't know, enforced amnesia culture happening. Because we've left the EU, we don't need to think about it anymore. We obviously do. And there needs to be, the question of remedies therefore cuts both ways. It's not just a case of a certain person's rights have been breached, and therefore what remedy should they get. It's also, and for anybody listening who is in the civil service as a lawyer, it is also for departments moving bills, moving secondary legislation, is this going to breach the Windsor Framework? Because if it does, you've wasted about a year's legislative time. Congrats for that.
It'd be worth acknowledging, I suppose, at that point that we did have more positive traction with the House of Lords. Now, we had more time to put thoughts to it and you know, in terms of the course of the passage, have more engagement. And we were also helped enormously by the fact that there was a House of Lords subcommittee of the EU Affairs Committee that was particularly engaged and cited on these issues and so on. But talking of legacy brings me back again to the point Hugh was making earlier about the way we read it. We were looking at Article 11 of the Victims Directive, the right to review of a decision not to prosecute, and reading across to Article 47 of the Charter. And Hugh, I'm wondering at what, is that the sort of an example where we might think about consistent interpretation in future cases where you might argue you know, that what we would need to be read into the Legacy Bill to comply with Article 47, read with Article 11, would be the following words: to require engagement with the family, to require a review of a decision not to, now it wouldn't work in that case because immunity meant there was no prosecution. Right. But is that the kind of thing where we might look to use consistent interpretation more in the future?
Well, absolutely. I mean, of course, as you say, with the legacy bill, not possible simply because of the immunity provisions. But no, I totally agree. I mean, to be honest, as an advocate, my first port of call is always consistent interpretation. For me, disapplication is the nuclear option, and it's something that a judge is reluctant to do. I mean, I had to decide. I sit as a deputy high court judge in London, and I had to decide a case based on human rights, and the advocate stood up and he said, well, this is a case about disapplication of an act of parliament. I said, that sounds a bit above my pay grade, doesn't it? But I mean, I was really keen to find a consistent interpretation because, that seemed like something that judges did. Disapplication is something you have to do sometimes, but, as I say, it seems like the nuclear, it was a declaration of compatibility there because it was just ECHR, but I mean, they're major things, and the way in which the Human Rights Act, of course, is set up is you've got to look really seriously. You've got to, follow the Guidan Mendoza criteria and see what you can really do to make sure that the provision works in an ECHR compliant way. So, it's in principle, it's a much more attractive pitch to a judge because you're asking him to do less.
Eleni, I think it's your section, of the report talks about the different cultures and how the UK courts weren't so inclined to look more broadly at the whole statute book. Could you expand a bit on that for us?
I would love to. So this is really interesting, actually, what Hugh's describing now, because at least, and it may just be my perspective, but our feeling was that UK courts were much more likely, much more prepared to go to the nuclear option than courts in other countries. For example, in France, you can just interpret things away a lot of the time, but in the UK, it was always sort of, and I'm thinking, for instance, of several of Lady Arden's judgments, for example, in IDT, credit card, and so on, where you could have had consistent interpretation under European Union law terms, but the courts wouldn't go there. And they would just go, right, okay, well, it's EU law, we disapply. And there are some obiter statements in those cases where, Lady Arden was really great about saying this, actually. That, she specifically said, well, we don't need to test the limits of consistent interpretation now, because we just don't have to. And for the time being, we will just deal with consistent interpretation basically under the Human Rights Act and under EU law in pretty much the same way. So that was really interesting because whilst the HRA and the Charter operated in parallel, there was that idea that consistent interpretation under both instruments was pretty much the same, the Guidan and Godin-Mendoza test, which we have found at the Durham Human Rights Centre that actually hasn't been used very expansively in UK courts over the years. So that's it's an interesting thing. Whereas courts might be prepared to sort of make small changes to the legislation, we found that they're not prepared to make drastic changes. And when it came to European law, and we see obviously some of the classic EU law cases on disapplication, really making that point, like Walker or Banker-Bush, etc. The remedy is disapplication, and consistent interpretation. It seems to me, at least, was sort of pushed somewhere in a dark corner, and we didn't really want to think about it whilst the other option was available, because I guess it was. I'm not sure why. And in the commentary, at least, and also Alison Young has written interestingly about this. That sort of it became run of the mill, and courts, even tribunals at lower levels, and especially employment tribunals, were using disapplication quite a lot. So this is an interesting, difference.
I mean, of course, Lady Arden comes from the Chancery Division, and the Chancery Division finds it more difficult than other parts of the court service to interpret broadly. Because they spend their lives interpreting wills and company memoranda and articles, and making sure that there's legal certainty is the big thing, But of course, although I mean Lady Arden is a magnificent judge, so probably less bound than others. But I suppose the problem really is this idea: are you going against the grain? And if you're thinking Ben Carbuche, so these are embassy staff claiming under EU directives, working time directives, discrimination directives, one of the other directives, against the embassy, argued against them. State Immunity Act says that we as embassies cannot be sued in this way. And so when you find yourself asked to do a consistent interpretation, then we have this against the grain principle. If it's against the grain, then you can't interpret consistently. And so where you've got something which says you will not have a right of action on state immunity grounds, then you can't interpret that to give somebody a right of action. That's the problem. So, but it's, inconsistent interpretation, I just go back to what I said right at the beginning, which is that it really matters which, how you try it, how you present it. Because, looking at it and really thinking about it, the exact words you're going to put in tend to come at quite a late stage. And they actually ought to probably come up because that's really what you ought to be thinking about how can you present it? How can you, in the Swedish case, in the Brathens case, which bit of the procedural code is it that if we tweaked, that would then give rise to this change? You're almost quasi-exercising the powers of a sort of legislative draftsman, aren't you? You're trying to think which bit we tweak with the least words so that then we can achieve the end.
A few minutes left. I wonder, would it be fruitful to explore your thoughts a little more on the theme of cases that Ty made reference to in terms of Article 1 and right to dignity of the human being? Obviously, we've had CG, we've had Shima and Ismail, which failed on different grounds, I suppose. But obviously, this seems to be a live area. I wonder, would any of you like to go out on a limb and say where you think this line of cases is taking us? You want to start, Ty? Maybe just.
Yeah, it's difficult to say at this stage because obviously we've only had the one really positive case in, I reckon, in terms of dignity, and we've had CG as well. And the good thing with the positive thing about bringing a challenge under Article 1 instead of, say, something like an ECHR Article 3, as Article 1 can be, the threshold isn't as high and it can be interpreted more broadly. So that is a very useful line of action or grounds of challenge to bring forward. And I was quite interested, Hugh, when you sort of said in the Ishmael case, it wasn't quite as clear-cut as it can't just be a freestanding CFR right. There was more scope in terms of, perhaps, were you alluding to the fact that you could have more of a general charter right, freestanding, say something like Article 1? Is that what you were thinking?
What I was saying was that CG and the Department of Communities appears to go a bit further than Mr. Justice Humphreys is saying in Shima Ismail. His reading is one reading of it, and it is the more orthodox reading of it. But actually, when you go back, because for Dillon, for the Court of Appeal in Dillon, I went back and I read CG and the Department of Communities, and it's quite difficult to see it as wholly orthodox, simply because, as I say, entry to the UK, so the exercise of the right of free movement, almost seems to be used as being a sort of a gateway. Once you're through it, then you're exercising your EU rights forevermore. And that's too far. But how far is not too far? How far is not too far? So what is the scope of that? And I thought that the Shima Ismail case is not the last word on that. It's probably, I suspect.
Do you think the difficulty in that case really was just they hadn't provided enough evidence? And I think perhaps in Angusham as well, we found some of their contentions, they just hadn't evidenced that properly, and therefore that was really detrimental to their case.
Yeah, because in Shima Israel they hadn't identified the relevant EU law right and then linked their evidence to the exercise of that EU law right, which seems to be fundamental, because it's only through that's a sort of jurisdictional gateway, and then you've still got the question of how far you can extend that EU law right. How far it acts as a gateway, and CG in the communities seems potentially far-reaching, and one would suspect that the Court of Justice will be asked in a future case, how far were you going there? And it may be then the Court of Justice will say, well, it's as Miss Justice Humphreys, in brackets, as Miss Justice Humphreys says, it's a purely orthodox application. That will simply depend on how the Court of Justice feels on that day.
I was really interested when I heard you both speak about this scope question, actually. And I wondered about the relationship between that sort of, the nature of the underpinning EU law. Because for us, I think we treated this very much as a similar question to the question of scope dealt with in Frantziou. But actually, the Court of Justice, especially in a case like Frantziou, treats a body of domestic law as if it were EU law, basically. So, and hearing you both speak, you both seem to take a slightly narrower view of what that underpinning might be. So, for example, if we took Frantziou, on its words, it could be that, say, completely, domestic legislation that had nothing to do with European Union law, but also acted in some way as an implementation of some EU measure, even if it didn't explicitly say so, could be considered to be the underpinning measure. And do you think that goes too far? I wonder. Sorry if I'm overextending what we said, Tobias.
I think possibly just the way I've approached today is obviously just how it's been litigated in the courts, and we've just taken a very conservative approach as well. So that's probably where we have that's how we have come across, because we only want to argue things that we know have a good basis for success. So that's possibly why it sounds like we have narrowed things down, perhaps maybe too far in your suggestion. But obviously, that's just something to build on in terms of cases as we bring forward and different types of challenges. I don't know what your thoughts are. You?
Yeah. I was just looking for the Lord Carr and the Kerr. I'm sorry, I never forget which way you pronounce that. He had some words in the rugby union case, which were a slight gloss on the implementation of EU law. Within the material scope, acting within the material scope.
So, for example, if you think of the Victims Directive and the the Justice and I Act 2015, which implements the Victims Charter, the Justice and I Act is implementing EU law. Therefore, it falls within the material scope of it, even though it's not a word-for-word copy of the Victims Directive. So that would, if you had to, if you built a case on saying the Justice and I Act needs a charter-consistent interpretation, it would have to have one. It falls within the material scope of it, because it is used to implement the Victims Directive, in certain ways anyway.
So we're going to give Tobias the last word today as we're running out of time.
That's in Frantziou as well. It's basically a functional thing. What function does the national law, the domestic law, fulfill? And if it just happens to fulfill that function, even though it was never in Frantziou, the legislation was from before Sweden even contemplated EU membership. It doesn't matter. It fulfills the function of implementing an EU law obligation, and you're in the charter. So that's all you need to be able to show. It's obviously easier if you have a provision of domestic law that says this is to implement Directive XYZ of the EU, but you can't always be lucky.
On the note of good luck, thank you so much, everybody. Lots to think about there, and can we just meet back here tomorrow to carry on, if that's 9 o'clock? So, particularly to our authors who have contributed huge amounts of time, I suspect well over and above what they were contracted for, and given us more food for thought than we could ever have asked for. To Hugh and to Ty, our panellists, to you, our participants, thank you so much for staying the course with us today, despite some fairly heavy material, and our participants online as well, thank you. And Ty will not be chasing you down to give out to you about your mobile phone usage during that. Thanks again to Ulster University and to Alan for our stalwart supplier of AV support. We hope you'll find the research useful. We hope you'll talk to us more about it. And we hope you'll keep an eye out for our other projects that are ongoing. So we've ongoing work on Windsor Framework Article 2 and environmental rights, which we hope to have out in the next few months. And we have a new project starting on EU Remedies building, and very much coming out of this report to look further at that, the interaction of EU Remedies in this post-Brexit context here. And then we're out to tender at the moment for a project looking at the UNCRPD and Windsor Framework Article 2. So lots going on, and stay tuned. Thank you very much.